New York just crossed a constitutional line that every lawful American needs to see clearly. On October 16, 2025, Governor Kathy Hochul signed A544B, Chapter 466, rewriting what happens in the first hours of a domestic call. The change sounds technical, but it is not. It lowers the trigger from probable cause to an officer's reasonable belief, makes short-term firearm custody mandatory, and stretches the government's hold to 120 hours before a judge even weighs in. That is pre-deprivation power over a core constitutional right. I'm not here to panic you. I am here to arm you with the facts and the playbook. We will examine exactly what the statute says, how the 120-hour clock works, and the specific moments where due process can be protected or quietly bypassed. If you value the Second Amendment, this is not background noise. This is where everyday procedure becomes the battlefield. What A544B actually does. I will break this down in plain English. New York's A544B, Chapter 466, amends CPL Section 140.106 to change what happens during the first hours after a family offense call. Under prior practice, officers already had routes to take temporary custody when making an arrest or during a lawful or consensual search. The new statute goes further in three concrete ways. First, it creates mandatory custody triggers. When an officer responds to a domestic offense incident and the Domestic Incident Report, DIR, reflects certain yes answers about threats, access to firearms, or lethality indicators, or B, the officer forms a reasonable belief that removing weapons is necessary to protect the victim or others or to prevent further violence or threats, the officer shall take temporary custody of any firearms found in plain view or discovered during a lawful or consensual search. The shift from may to shall is deliberate. In qualifying circumstances, seizure is no longer discretionary. Second, it establishes a time-boxed window. The minimum holding period expands from 48 hours to 120 hours. Within that window, the state can seek a court order, for example, an order of protection, OOP, or an extreme risk protection order, ERPO, or proceed with disqualifying charges. If no legal impediment is found, property must be returned. In other words, A544B governs immediate short-term custody. Any longer-term dispossession still runs through a judge. Third, it ties the policy to standardized risk tools. The law expressly references the DIR and lethality screening that have been institutionalized in New York's DV response. The legislature's logic is that these tools capture near-term risk better than waiting for probable cause thresholds tied to arrest decisions. For viewers, the takeaway is practical. At DV scenes, officers are now required to act on specific, articulable safety signals even where no arrest occurs. What this really means, if those DIR boxes light up or the officer forms a reasonable belief, I lose immediate control of lawfully owned property even when no arrest is made. This is not a hypothetical. It is now the mandated sequence. The standard shift, reasonable belief or suspicion versus probable cause. Let us demystify the legal thresholds. Probable cause is the higher standard, facts and circumstances sufficient to warrant a person of reasonable caution to believe that a crime has been committed or that evidence will be found. It is the traditional gateway for arrests and warrants. By contrast, reasonable suspicion or belief is a lower threshold, specific, articulable facts that suggest criminal activity may be afoot, or, in this statute, that immediate safety requires intervention. Courts accept reasonable suspicion for brief stops and limited intrusions when safety is at stake. Why it matters here, A544B authorizes initial short-term firearm custody at a DV scene based on reasonable belief tied to DIR answers and lethality indicators, even without an arrest. That is a pre-deprivation step. The state may act first to prevent harm, then pursue judicial process during the 120-hour window. This does not erase due process, it resequences it. Judges remain the arbiters of any ongoing dispossession through orders of protection or ERPOs. The statute's theory is that imminent risk facts uncovered at the doorstep, threats, escalation patterns, access, can justify temporary custody before the higher probable cause threshold for arrest is met. For owners, here is the non-negotiable truth. Once that reasonable belief threshold is met, custody is mandatory and the burden shifts to you to navigate the next 5 days. The state chose to act first and litigate later. If we do not understand this shift, we will misplay the only window where our rights can actually be defended. The 120-hour timeline from doorstep to court. Here is the practical sequence I want every lawful owner to visualize. Step 1. Response. Officers arrive on a family offense call and complete the Domestic Incident Report, DIR, which includes a lethality screen about threats, access to firearms, and recent escalation. Step 2. Triggers. If the DIR yields certain affirmative answers or the facts create a reasonable belief that removing weapons is necessary to protect the victim or others or prevent further violence, Section 140.10.6 now makes custody mandatory. Officers shall take any firearms in plain view or located during a lawful or consensual search. Step 3. Custody and transfer. Firearms are booked per department policy. You should receive property documentation listing the items and storage location. Step 4. The 120-hour window. The state has up to 5 days to secure a court order, for example, an order of protection or an extreme risk protection order, or to proceed with charges that legally bar possession. Step 5. Return or continued hold. If no court order issues and there is no legal impediment, property must be returned after the window closes. Sequence is the shield. A544B front-load seizure power then forces you into a timed race to a courtroom. Miss the paper trail, miss the deadlines, and you fight uphill. Hit the paperwork, demand receipts, track the 120 hours, and you force the state back into the lane where a judge must decide. That is how responsible owners win under bad policy, by knowing the rules better than the people who wrote them. How this fits New York's existing DV and firearm frameworks. Before A544B, New York already blended DV response with firearm controls through several channels. Arrests and lawful searches at DV scenes could lead to temporary custody under prior CPL authority. Judges could later impose conditions via orders of protection that restrict possession. And since 2019, ERPOs allowed civil, time-limited disarmament upon judicial findings. Those tools remain. What changed is the field-level threshold and mandate. With Section 140.10.6 amended, officers are no longer merely permitted, but in qualifying circumstances required to take temporary custody based on DIR-linked lethality indicators or reasonable belief about immediate safety, even without an arrest. The minimum hold expands from 48 to 120 hours, a defined runway for the state to secure an OOP or ERPO or advance charges. The statute thereby standardizes and codifies what had been patchwork practice, anchoring it to the DIR and lethality assessment that New York has already institutionalized. Supporters will say, nothing to fear, judges still decide long-term. Here is my answer. The danger is front-loaded. Rights are most vulnerable before the first hearing, not after. That is why the statute's mandatory seizure matters more than the later promises.
I want to weigh this the way a court will, through the Fourth Amendment, due process, and the state's asserted compelling interest in preventing lethal domestic violence. The constitutional friction point is the entry-level standard. Probable cause has long anchored arrests and warrant-based seizures. Reasonable suspicion or belief permits narrower, short-term intrusions when officer safety or imminent harm is at stake. A544B uses that lower standard to authorize initial firearm custody at the scene, then pushes longer possession decisions to the courtroom during the 120-hour window. From a policy perspective, the legislature's theory is straightforward. Domestic homicide risk spikes around moments of separation or escalation. If the DIR or lethality screen flags danger, the state wants officers to act immediately. That is why Section 140.10.6 is written around plain view and lawful or consensual search contexts. No expansion of search authority is claimed. Counter-argument 1. It saves lives in the gap. I agree the gap is real, but the Constitution requires the state to justify intrusions with clear, articulable facts and prompt judicial review. Risk tools can help. They cannot replace individualized findings. Counter-argument 2. Officers need discretion. Discretion is not the issue, compulsion is. The statute converts professional judgment into a mandate, even without arrest. That is where abuse and error multiply. Counter-argument 3, courts will sort it out later. Later is too late for the owner disarmed without arrest who missed the window to challenge. Rights are not theoretical, they are procedural. If we allow front-loaded seizures to become routine, later will always arrive after the damage. Where do I land? Short-term custody, keyed to structured risk signals, with a tight judicial backend, can pass constitutional muster if agencies maintain documentation, chain of custody, and prompt court access. The litigation battleground will be implementation, whether officers articulate facts that formed reasonable belief, whether returns happen on time, and whether courts police the boundary between temporary and extended dispossession. On-screen hot cues, mandate doesn't equal discretion.
Practical guidance for lawful gun owners. Here is how we fight smart and lawful. Documentation is leverage.
Your permits, serials, photos, and incident numbers are the tools that force accountability inside the 120-hour clock. If the state must act first, you must be ready faster. That is the difference between a clean return and a quiet, indefinite delay. 1. Before anything happens, keep a simple file. Permits, purchase records, serial numbers, and photos of your property. Store a digital copy. This makes return logistics far smoother if custody occurs. 2. If officers respond to a family offense call, expect the DIR and lethality questions. Cooperate lawfully. Do not obstruct. If you consent to any search, make sure your consent is clear and limited. Remember, Section 140.16 focuses on plain view and lawful or consensual discovery. It does not grant new search powers. 3. If custody is triggered, ask politely for the property receipt listing each item, the agency case number, and the storage location. Note the date and time of seizure. This starts your 120-hour clock. If you have counsel, notify them immediately so they can monitor any OOP or ERPO filings. 4. Inside the 120-hour window, check whether the state seeks an order of protection or an ERPO. Those are the judicial forms where you can contest allegations and present evidence. Calendar the deadline. If no order issues and there is no legal impediment, begin the return process with the agency's property office, referencing your receipt and incident number. 5. After return, or if an order issues, if you get your property back, document its condition. If a judge issues an OOP or ERPO, read the terms carefully, note expiration dates, and follow lawful avenues to modify or dissolve the order when appropriate. Key mindset. This law is about sequence, not surrender. Know the rules, keep records, and move quickly to the courtroom when it matters. Responsible ownership includes legal readiness. On-screen hot cues. Documentation equals leverage, ready faster than the state. Policy can sound polite while power grows teeth. A544B hands the state pre-hearing control over a constitutional right and tells you to trust the system to fix it later. I will not tell you to trust. I will tell you to prepare. Know the trigger points, demand the paperwork, run the 120-hour clock like a stopwatch, and get to court when it counts. We can support victims and protect due process at the same time, but only if citizens understand the rules as well as the people enforcing them. Share this with someone who thinks the procedure is boring. Procedure is how rights live or die. Responsible ownership is more than range time. It is readiness, records, and resolve. I am here to make sure you have all three. On-screen hot cues. Procedure protects rights, run the clock, records, readiness, resolve.